You missed court, you avoided arrest, and now you want me to lower your bail? Judge's voice cuts through the courtroom like a knife. This isn't just bad judgment, Mr. Taft. This is criminal thinking. The defendant fidgets nervously. His excuse? I lost track of time, but the judge isn't buying it. She's furious, and what happens next will leave you speechless. Will she cut him some slack, or has he run out of chances? Stay tuned to find out why this case takes a shocking turn.
I don't believe you. So in fact, I'm raising bail to $2,000. $2,000 cash bail. Now, that's what it's going to be. We will go on the record in the matter 24 CM 127, State of Wisconsin versus Nicholas Butkus Taft. The state appears through Assistant District Attorney Holly Rockow in person. We have Mr. Butkus Taft appearing by video conferencing in custody in Burnett County Jail. We have Zachary Fisher, defense counsel, also by video. We're set today in this matter for a status conference. Mr. Fisher, please update the court.
Your Honor, Mr. Butkus Taft was picked up on the warrant after he missed the last status conference, as his reason was not an emergency. I did discuss this with Mr. Butkus Taft, and he does understand ultimately that it was entirely his fault and that...
This heated courtroom exchange takes place in a Wisconsin court, where the judge delivers a fiery reprimand to defendant Nicholas T. Butkus Taft after his arrest for failing to appear at a prior hearing. Taft had a court date scheduled for February 6th, which he skipped, prompting the issuance of an arrest warrant. Rather than turning himself in, Taft continued his daily routine, claiming he was working to save money for his bond. He was eventually arrested over a month later, on March 11th. During the hearing, Taft's defense attorney, Zachary Fisher, explains that his client regrets missing the hearing and is apologetic. Fisher asks the judge to reinstate a signature bond or reduce Taft's cash bail so he can keep working and begin paying restitution, which amounts to roughly $11,700. Fisher adds that they had intended to prepay at least $2,000 toward restitution as part of a plea agreement. The judge, however, is unimpressed and visibly frustrated. She calls Taft's excuse of losing track of time on the court date baloney, and points out that he had over a month to turn himself in or ask his attorney to file a motion with the court. Instead, he ignored the warrant and continued with his life.
He, regardless of other outstanding obligations, needed to make sure that this was his first and most important obligation due to the seriousness of these allegations and ultimately that this is a court-ordered request, and it's not a request, it's a court order. He was very apologetic, and if you would like him to make a statement, I am not opposed to him making one today. I will just say that we are ready to resolve this case. We would be ready to schedule this for a plea and sentencing if Mr. Butkus Taft was to have his bond amended either to a signature bond or to have his signature bond reinstated, or if his cash was reduced. Ultimately, Mr. Butkus Taft was working before he was arrested. I'm hoping that that job is still available because ultimately I know the money is going to ultimately go towards this restitution that he needs to save up for and pay. And I just hope that he would be able to go back to the community, make sure he keeps working, saving up money for this restitution, because our goal, I believe, will that he prepay quite a large amount. I don't have a specific amount on me right now. I believe it's somewhere in the ballpark.
11,000 something, 11,700 and something, I believe.
Yes, and I believe we were looking at prepaying at least about 2,000 was our goal that we were planning for. So my hope would be that with some time, if he was released from custody, he would be able to save up some money, and then we would be able to come to an agreement that would resolve these matters and benefit Mr. Taft as well as the victims in these matters. So for those reasons, I would request that the signature bond be reinstated, and or that if there is concern for flight risk for the missed court appearance, I would ask that a lower cash bond be imposed.
Mr. Butkus Taft, why weren't you in court?
Your Honor, like my attorney said, I take full responsibility for it, but it was an honest mistake. I had my outpatient treatment group until 10 a.m. that day. And just lost track of time. My kids were home from school that day, and they had conferences that my wife was going to go to. So I just started helping them get ready, lost track of time. And it was unintentional, but it was all my responsibility to make that court date, and I didn't, so just lost track of time, Your Honor.
Are we in victims' rights compliance for a modification request?
Yes, Your Honor, I did speak. I did contact the victim.
Ms. Rockhow?
I might have missed this, but did he turn himself in or was he arrested on
He
the
was
warrant?
picked up in Marin.
As though nothing had happened. The judge emphasizes that individuals who genuinely wish to resolve their legal issues take responsibility by turning themselves in and seeking leniency. She describes Taft's behavior as criminal thinking, noting that it's especially concerning given the serious charges he faces and the large sum he owes in restitution. Given her doubts about Taft's sincerity, the judge refuses to lower his bail and instead raises it to $2,000 cash, making it clear that he'll need to figure out how to post it if he wants to be released before the next hearing. The court schedules a follow-up status hearing for April 7th at 10:45 a.m., at which time they will revisit the possibility of a plea deal. Fisher hopes that by then, they will have made some progress toward restitution payments. Key takeaways. The judge is exasperated by Taft's avoidance of arrest and dismisses his excuse. Taft's bail is raised to $2,000 instead of lowered. As the judge doesn't trust his intentions, the defense attorney argues for leniency, stating that Taft is now willing to cooperate and pay restitution. A new status hearing is set for April 7th at 10:45 a.m. to discuss a possible plea deal.